In this episode, we talk about the recent drone attacks in the Red Sea and the security concerns they raise for India. We also talk about Defense Minister Rajnath Singh visiting Jammu and Kashmir and meeting the families of the 3 civilians who were killed last week. But first, we talk about the new criminal laws that were passed by the Lok Sabha last week. Hi, I'm Shashank Bhargav, and you're listening to Three Things, the Indian Express news show. Last week on Wednesday, the Lok Sabha passed 3 bills which will replace India's colonial-era criminal laws. That is the Indian Penal Code, the Code of Criminal Procedure, and the Indian Evidence Act. Among these 3 bills, the Bharatiya Nyaya Sanhita is the one that is set to replace the Indian Penal Code, and it makes several key departures from its older counterpart, from bringing terrorism and organized crime under the ambit of ordinary criminal law to expanding detention in police custody and, in a certain sense, criminalizing consensual sexual activity. In this segment, we speak to Indian Express's Apurva Vishwanath about these changes and what they mean for the average citizen. Apurva, the government has been saying that these bills completely overhaul the country's criminal laws. To what extent is that the case?
So there are 3 new legislations which will now replace the IPC, CRPC and the Evidence Act. Along with the Code of Civil Procedure, which is left untouched, these 3 laws form the fulcrum of how our courts run. Our substantive criminal jurisprudence is governed by these 3 laws. So what has the government done now? Of course, while introducing these bills in the parliament for the first time in August, Home Minister Amit Shah said that this is a complete overhaul of the Nyaya Vyavastha, as he put it. But is it a completely new piece of legislation? Once you look at the fine print, that is not the case. There are some key changes in the IPC, some in the CRPC as well. The Evidence Act is largely left untouched. What you see in the Evidence Act are 2 kinds of changes. One, cosmetic changes, where some colonial references, say for example, where it said Lahore and Calcutta has now been made Lakshadweep and Chennai, in examples and illustrations. The other change that you see in the Evidence Act is, of course, the inclusion of digital evidence. So now each provision where it talked about evidence in the old world sense now also includes the aspect of technology and digital evidence to be included, which is not to say that it doesn't happen right now. Of course, having it in the legislation itself makes it much more easier. So apart from that, the Evidence Act is largely untouched. Now you look at the IPC and CRPC, there are quite a few changes. But does that mean an overhaul or a rewritten legislation? That does not seem to be the case.
And when we talk about the Bharatiya Nyaya Sanhita bill, that is the one that is set to replace the Indian Penal Code. What would you say have been the biggest changes under it?
So when it comes to the Indian Penal Code, I think the big change is, of course, has been to include anti-terror legislation that deals with corruption, legislation that deals with organized crime. These are all special legislations and far more stringent than ordinary criminal law. Take, for example, the UAPA or the MACOCA, which is the Maharashtra Control of Organized Crime legislation, or the PMLA, which deals with serious economic offenses. These are stringent special legislations because they do create a departure from ordinary criminal law, in the sense that all your basics of first principles of criminal law, that you are considered an accused until you're proven guilty. So as an accused, you get certain liberties from the court. All of these things are sort of upturned in these stringent legislations. The onus of proving that you didn't do the offense shifts on the accused rather than the prosecution. Here, the state gets a lot of concessions as well. There are timelines are relaxed when it comes to filing of charge sheets, when it comes to holding the trial in a certain period of time. So where the state gets a lot of free pass and the bar for the accused is much higher, it made sense to have them in separate legislation. So that when, case under UAPA is being tried, it happens in specially designated anti-terror courts.
Yeah, and you're doing this because you're saying that organized crime is a much more serious offense. Terrorism is a much more serious offense.
Correct. And there is a big understanding when it comes to, these cases being tried in a separate court. You have special prosecutors to try these cases for the government. So where the state gets a larger leeway. There is a mindset shift as well when all of this is kept separate from ordinary criminal law. It's not just for the sake of convenience. It is also to ensure that the leeway that the state gets doesn't seep into ordinary criminal law. For example, somebody who commits theft should not be looked with the same lens as someone who's accused of a terror plot. So this shift, this wall that separated these two has now been taken away. So you have, for the first time, terrorism, anti-corruption, organized crime under the purview of ordinary criminal law.
And what does this shift mean for cases like these? How will it change the way terror and organized crime cases are dealt with in the court?
So for starters, there is little clarity on how, because we still have the special laws, right? So we still have the UAPA, we still have the Prevention of Corruption Act, we still have state legislations like Makoka. So how that will be applied with the IPC provisions or now the Nyaya Sanhita provisions is something that we'll have to see. But what you can glean from this change is, of course, the intent of the legislation for the state to have much more influence on every aspect of criminal law, whether it is petty crime or whether it is terrorism. So you'll see the state's omnipresence everywhere. So it is one code for all of these offenses. I mean, critics could go as far as to say this will create a police state because you might have, if the same judge is dealing with all of these cases, that mindset shift that we talked about, that could get affected. But for the government, it's still, we don't know why we have special legislations and also provisions in the Nyaya Sanhita at this point.
Right. And Apurva, besides this, the BNS also introduces Clause 69 that appears to tackle the whole love jihad narrative. And people have been pointing out that a phrasing in this clause essentially criminalizes consensual sexual activity. So can you talk about what this clause is and how it does that?
Yeah, so Clause 69 criminalizes two aspects. One is marrying through deceitful means and two, breaching a promise to marry, right? Breach of promise to marry has been a very contentious issue. There are different court rulings on this aspect. But by and large, the question really is whether the state should enter the zone of consensual relationships gone wrong. Is the state going to be policing consensual relationships? That becomes a question essentially. So basically, if you promise to marry somebody and based on that promise, you've entered into sexual relations, if the promise is broken, should you be charged for rape? It boils down to that basic question. From a libertarian perspective, the state has no business regulating consensual relationships. If a relationship has been broken off, unless there is a zone of criminality, which is when there is rape. But what is rape? In this case is, something that the state insists that when you break a promise to marry, it becomes rape. So at the time of sexual activity, there is consent. But what the provision is now saying is if that consent is subsequently withdrawn, that can still be rape, which is a scary situation to think of because you look at consent when the activity is taking place. Sometime in the future, based on whether or not some other things happen or not. So that part is problematic. But if you look at the wording of the provision, it says there is a phrase which is used as what is deceitful means. And the explanation to the provision explains what is deceitful means. And there it says being deceitful on the grounds of religion or other inducements. So once you're policing consensual relationships, say somebody who has concealed their religious identity, that could become rape now.
Right, and in that sense, relationships that are interreligious could very much be under threat because of this. But talking about other changes, the BNS also codifies offences linked to mob lynching and hate crime murders. Apurva, how are these crimes being dealt with right now?
So it's not as if mob lynching is currently not prosecuted under existing criminal laws. But of course, there's been a call for a new special provision to tackle this specific issue. Legal experts, of course, differ on whether having a special law will deter people from committing these crimes. But what this provision does is now in the Bharatiya Nyaya Sanhita, that it codifies, it for the first time uses language where it says where a person commits murder based on factors such as race, caste, community, or personal belief. So it is in a sense acknowledgement from the state that these sort of offenses happen. That is also signaling. And this is specifically criminalizing a mob. What becomes difficult in these cases to prosecute is how to identify the mob. What is the gravity of each person's participation and how do you punish them? Do all of them get the same sentence? Should it make a difference whether somebody actually made the blow? versus somebody who was just participating in the mob otherwise and shouting slogans. So that aspect is what is difficult to get convictions in such cases. The provision, of course, while it recognizes, that aspect is still unsolved. That is still a challenge for courts that they have to decide. Initially, in August, the first version of the BNS prescribed only a sentence of up to 7 years for this offense. Of course, now that has been brought in par with any other murder. So mob lynching is now, under the new code, a different kind of murder.
And the other thing is that according to the government, 3 specific provisions that have been symbols of the colonial imprint of the IPC, sedition, criminalization of homosexuality, and adultery, have been repealed. Now, back when these bills were introduced, we had talked about how sedition has not really been removed, it has just been introduced under a different name. Does that still remain the case?
Yes, sedition is very much an offense even now, except that the phrasing of it has changed from, say, Rajdroh to Deshdroh. So earlier you would offend the state, but that state was, at the time when the provision was brought in, a colonial state. Of course, that hasn't been the situation after 1947, right? And it has been used by successive democratically elected Indian states. So it's incorrect to say that this provision was just colonial earlier and now, it is for the state. It doesn't matter who the oppressor is if there is oppression. So in that sense, the offense of sedition is still very much on the books with the same language. The only thing that has changed in it is a safeguard which the Supreme Court had put in, which now has been codified into it. But even under the IPC right now, the provision sedition itself is read with the Supreme Court guidelines. And that's how it's implemented. So it's old wine in a new bottle. Sedition is very much an offense on the books even now. And that sort of tells the larger narrative of decoloniality or indigenization when it comes to these 3 criminal law bills. What is indigenous about it? Because by and large, we've retained the provisions. And when it comes to the tweaks made, they are expanding the state's powers rather than shrinking it. And where it is about removing certain offenses, say, for example, adultery or homosexuality, these have been done by the Supreme Court already. So the solutions then seem to be merely cosmetic. On the larger prescription of what the government is doing, there doesn't really seem to be a decolonization pitch that leaps at you from any of these 3 sanhitas.
Right, and besides what we've talked about, there are other changes as well that have been made, and we'll provide a link to your piece in the episode description. But finally, what would you say these changes mean for the average citizen? What do they mean for people like you and me?
I think the biggest change from day one when you will see these laws implemented is, of course, the period of custody. That is the most troubling part of the changes that have come in through these sanhitas, which is a change made in the Bharatiya Nagrik Suraksha Sanhita, which now replaces the CRPC, the Code of Criminal Procedure. What change it makes is that the police could have custody of an accused for a period of up to 15 days and not more than that. Now that has been tweaked to allow for custody up to 90 days for some offenses and even beyond that for other offenses. Why was this 15-day limit prescribed? Because police torture and custodial interrogation is not a new thing. That is something that we all know happens. But of course, is it easy to address? It's not. So what the state did earlier was to provide procedural limits to that power, because you can't substantively change this overnight. They prescribed a 15-day limit saying that the police can only have your custody for 15 days. So after that, you're under judicial custody, which means you're, say, in a central jail. You're under the supervision of the court, not the police themselves. This also ensured that if the police has only access to the accused for 15 days, then they will be forced to finish the investigation sooner rather than just keep you in custody for longer periods. That radically changes not only the fact that, your liberty could be curtailed for longer, but how it affects the trial as well. It definitely gives more powers to the police while curtailing your liberty for longer periods. Remember that we are not talking about convicts who by court have been mandated to undergo a sentence. We are talking about those who've been accused, and at that stage, at the most preliminary stage, that you will spend longer in police custody than you do right now.
And next we talk about the Israel-Hamas war. For nearly 3 months, the unprecedented war between Israel and Hamas has continued to escalate. resulting in a rising death toll that may soon reach 21,000. And what's crucial to note is that a significant number of these casualties comprise Palestinian women and children. Now, the fallout and consequences of this war have been numerous. One of these repercussions is that it is now affecting international cargo ships. For the past few weeks, there has been a surge in drone and missile strikes that have disrupted maritime traffic in the Red Sea and beyond. For instance, last Saturday, the merchant vessel MV Chem Pluto with 21 Indian crew members was struck by a drone about 217 nautical miles from Porbandar. To understand why such drone attacks are taking place and the concerns they raise for India, Indian Express's diplomatic editor Shubhajit Roy joins us. Shubhajit, it has now been nearly 3 months since the latest Israel-Hamas war began. Could you tell us where things stand at the moment?
Well, the war is obviously has been devastating for both sides. Firstly, over 1,200 people on the Israeli soil were killed by Hamas on October 7th. And after that, there has been a Israeli offensive, which included airstrikes as well as ground offensive. As per the latest report, almost close to 21,000 Palestinians, people in Gaza, have been killed. These figures don't differentiate between civilians and combatants. That is one thing to be kept in mind. But having said that, 2/3 of these victims are women and children. And right now, more than 150, I think, people are still hostages from the Israeli side kept by the Hamas. And there's been no change or no let up on the strikes or the ground offensive by the Israeli military. This has also led to a humanitarian situation, and food, water, fuel, medicine shortages are rampant. And that has been a challenge for the UN agency, UNRWA, to sort of service or provide for the services for the people in Gaza. So overall, there has been kind of a dire situation as especially the winter has now set in the region.
And Shubhajit, for the past few weeks, a number of missile and drone strikes have been taking place in the Red Sea where a lot of commercial ships pass. Last week, 2 India-bound cargo ships, including one oil tanker with 21 Indian nationals, was attacked by a drone. Could you talk about who has been behind these attacks and the concerns this raises for India?
Well, this is the Houthi militant group, which has been in control of parts of Yemen. And they have been in solidarity with people of Gaza. They have been conducting airstrikes and drone strikes at the commercial vessels and ships passing by Red Sea. Houthis are perceived to be backed by Iran. And the US, in fact, has alleged that Iran is behind these strikes, but Iran has rejected these allegations. As a result of these drone strikes by the Houthi militant group, a lot of these vessel companies have tried to reroute their journey, and that has caused some kind of disruption in the maritime traffic in the region. And this has raised concerns for India as well. In the last week, 10 days, Indian Prime Minister has spoken to Israeli Prime Minister Benjamin Netanyahu. So that has been the state of play as of now in the wake of these drone strikes by Houthi militant group.
And one of these drones was reportedly spotted around 200 nautical miles off Porbandar. Does that raise security concerns for India?
Well, so far, yes, these 2 attacks that took place, they have obviously drawn some bit of concern from India. India has obviously been very careful in not responding politically. They have only said that they support the free movement of freedom of navigation, free movement of ships and merchant vessels and commercial shipping in the area. Indian Navy has deployed some of its assets or redeployed some of its ships in the region. And US Navy and some other powers, Western powers, have also sort of joined in to ensure safety and security of the merchant ships. So it's one of the main lifelines for goods to pass through Red Sea, which connects between Europe and South Asia and beyond. So it's an important route, and from that perspective, it has strategic security concerns for India.
And Shubhajit, on Tuesday, PM Modi had a phone conversation with Saudi Arabia's Crown Prince and PM Mohammed bin Salman. Talk about what was the idea behind this call and the significance of India-Saudi ties at the moment.
Well, this conversation obviously is between the two leaders of these two countries, India and Saudi Arabia, because, Saudi Arabia is seen as one of the influential and, key strategic partners in the region. And so both share the concern in terms of security of the situation. India has a strategic partnership with Saudi Arabia, and this particular call was in that context of the instability or the lack of security in the region in the wake of the war in Gaza, as well as these attacks by Houthi militants on the vessels in the Red Sea. Now, obviously, India would want that these attacks targeting a route that allows this east-west trade, especially of oil, to stop. And so it's a strategic sort of a decision to talk to each other and find a way out so that these maritime disruptions, because they lead to more time and expense of journey in terms of trade routes. So that's the reason why this call is important.
And in the end, we talk about the Defense Minister's latest visit to Jammu and Kashmir. Last week, 3 civilians were killed in Jammu's Poonch district, allegedly after being questioned by security forces regarding a recent terror attack. The incident sparked significant outrage in the region, prompting responses from both the People's Democratic Party and the National Conference. Now, yesterday, that is 5 days after their deaths, Defense Minister Rajnath Singh visited Jammu and met with the families of the victims and assured them justice. In addition to this, Singh also met with 5 individuals who were reportedly tortured by security forces and are currently receiving treatment at the Government Medical College Hospital in Rajouri.
मैं आपको आश्वस्त करना चाहता हूं कि घटना की गंभीरता को देखते हुए जो भी आवश्यक और जो भी उचित कदम है वह उठाने की भरपूर कोशिश की जा रही है। हमारे लिए हर सैनिक बेहद महत्वपूर्ण है और हमारा एक सैनिक मैं मानता हूं वह हमारे परिवार के सदस्य के समान है। यह हम सब के अंदर यह भावना रहती है।
Noor Ahmed, a head constable in the Border Security Force, whose younger brother Safir was among the deceased, told Indian Express's Arun Sharma that the Defense Minister expressed grief over the death of their family members and said that whatever happened was very wrong. He assured that justice will be done. Another family member informed Arun Sharma that the Defense Minister inquired with the Lieutenant Governor Manoj Sinha about the government assistance extended to the families. They were assured that steps had been initiated to provide a government job to the next of kin. Regarding the injured individuals receiving treatment in the hospital, Rajnath Singh inquired about their condition and the medical facilities provided to them. The district administration has promised 30 lakh rupees, a government job, and a 10 marla plot in Surankot to the next of kin of each deceased. Out of this, they have already dispersed checks of 10 lakh rupees each. You were listening to 3 Things by the Indian Express. Today's show was edited and mixed by Suresh Pawar and was produced by Niharika Nanda and me, Shashank Bhargav. If you liked the show, then do subscribe to us wherever you get your podcast. You can also recommend the show to someone you think will like it, share it with a friend or someone in your family. It's the best way to get to know about us. You can also tweet us at Express Audio and write to us at podcast@indianexpress.com.